Responsibility is convened in the matter of Kevin P. Murphy, board docket number 24-BD-602. Will the parties identify themselves, please, for the record, starting with disciplinary counsel?
Good afternoon, Kevin Murphy, respondent.
And Mr. Murphy, you're representing yourself in this matter. Let the record show that board member Mr. Brost, who is one of our attorney members, is recused and will not be participating in this case. Let the record also show that attorney member Michael Tiger is participating remotely via Zoom. We are here on exceptions to the hearing committee report from respondent, who will proceed first. Mr. Murphy, you will have 20 minutes. Do you want to reserve some of your time for rebuttal? If so, how much time? All right, thank you. Before we begin, please be advised that the identity of the client in this matter should not be publicly disclosed, as per the board order issued on July 15th, 2025. Mr. Murphy, you may proceed.
Good afternoon. My name is Kevin Murphy, and I am the respondent in this matter. As I mentioned and the board knows, I am representing myself pro se in this matter. If the board determines that sanctions are appropriate in this matter, a 30-day suspension stayed for 1 year while the respondent is on probation is an appropriate sanction given the totality of the circumstances in this matter. This disposition would not be inconsistent with prior board decisions nor decisions of the District of Columbia Court of Appeals, pursuant to DC Bar Rule 11, Section 9H1.
Mr. Murphy, since you started on this point and saying that your proposed sanction would not be or would be consistent, wouldn't the sanction recommended by the hearing committee of 90 days also be consistent and within the range of sanctions for similar misconduct? Yes,
but there is a wide latitude that the board has in making its determinations. And as the hearing committee noted in their report, In re Evans was determined that a 30-day suspension with a 30-day sanction with 1 year probation was appropriate in that case. And I believe that my case is less severe than the facts reveal in Evans.
Please proceed.
Okay. As I was about to say, I'm not asking this board to do anything.
Excuse me, Mr.
Yes.
Murphy. I had a question since you brought up In re Evans.
Yes.
I noted that you had different positions in your reply. First, you said the 1 year suspension stayed while the respondent is on probation is appropriate. Then second, you noted, this is on page 10, I believe, that there is a precedent for your proposed 30-day suspension stayed in favor. So why do you believe Evans is analogous if Evans didn't involve dishonesty?
Evans did, involve dishonesty. Mr. Evans did not file a post-sentencing motion, ignored court order resulting in dismissal of appeal, and did not inform their client or take any other actions to reinstate. I am here because my actions involved dishonesty through omission. I did not tell my client LCQ that I had failed to respond to a notice of evidence in a timely manner, and that her I-360 petition had been denied.
Was it your omission? It was of a material fact. So why is that not dishonesty?
So I am not, so two things. First of all, I am not saying that I was not dishonest to my client with my lie of omission. Second of all, there's a question of whether this truly was material fact. As both the hearing committee and disciplinary council noted previously. Excuse me. Given the circumstances and the lack of communication and supervision by my identified mentor, Ms. Lee, there's a question as to whether the facts that have been disclosed were affirmative statements which are required for a material fact to be established under Rule 4.1.
Mr. Murphy, may I ask, I may complicate your analysis a bit. I want to ask you first about what appears to be a potential misstatement to the board on your part, and then how that factors in to your sanctions analysis. In your exceptions to the ad hoc hearing committee's report and recommendations as to sanctions, you state that even the committee concedes, given Ms. Lee's lack of communication and supervision, quote, there are questions as to what material facts may have been disclosed. But in fact, the hearing committee in its report said, respondent asserts vaguely and without explanation that under the circumstances, including Ms. Lee's alleged lack of communication and supervision, there are questions as to what material facts may have been disclosed. So it appears you were quoting your own statement as a statement of the hearing committee. Was that not a misrepresentation? And if so, how should we factor that apparent misrepresentation into our sanctions analysis?
So if I was misquoting, and I may have been, as a contract attorney, I am paid hourly and I have to work sometimes extended hours. I was drafting my brief very late at night, and I may have misread part of the record, but I also, and where my confusion may have come in is that disciplinary counsel in their initial post-trial brief did note that there were questions as to the information. So I will concede that I may have misrepresented the hearing committee's position there. It was not intentional, but obviously it is on the record.
And how should that be factored into our sanctions analysis?
I don't believe that the question of whether the lack of supervision, my question is, even though the hearing committee noted that there may have been material fact, I still question whether there are material facts there. And so although I may have misstated in my brief, I still believe that Rule 4.1 is not applicable in my case for a number of different reasons.
You want to give those reasons then?
Sure. A few things that I would note. As I just mentioned, there's a question of whether there was material fact as defined by the rules and Court of Appeals decisions. There is not clear evidence that my omissions to Ms. Lee and to LCQ rose to the level of material fact. I would also, and although it is not in my brief, I would also question whether Ms. Lee can be defined as a third person. I understand that comment 1 to the rule says that a third person is anyone but the client, but I would make the analogy that Ms. Lee was a necessary party, and given the totality of the circumstances, you know, her position would be analogous to a corporate attorney bringing in accountants to assist with a matter, and if they revealed information to the accountants as a necessary party to the matter, they would not be defined or acknowledged as a third person, as is necessary for Rule 4.1. There's also a question of whether my errors of omission were truly false statements. None of the statements that I made to Ms. Lee or LCQ, and I will concede that I very carefully worded my emails and my oral communications with Ms. Lee, but I did not affirmatively make any false statements. I contest.
Why is it that you had to be so careful in your wording if you were not trying to make a misstatement of material facts by omission?
I was trying to hide the mistake that I made, the prejudice that I may have caused LCQ from Ms. Lee, LCQ, and I told nobody else about my actions or inactions at any point. I felt very guilty. I know that I hurt LCQ. I know that I caused her prejudice by delaying actions that I, as her pro bono counsel, may have taken on her behalf. As I felt bad for her, and I try to cover up my mistake. But ultimately, I was the one who contacted Ms. Lee and informed her of the mistake. That was not available or known to her or anyone else until I told Ms. Lee.
How much credit, Mr. Murphy, do you really think you should get for waiting 3 years, even if it's arguable that you did it on your own, of your own volition? You waited 3 years to do this. So how much of a crediting factor ought that to be?
I'm not arguing that I should be given a lot of credit. I know that the 3 years was, prejudicial to my client during that time. But I also believe it is pertinent that I was the one who revealed the information to Ms. Lee and had it become public. Although highly unlikely, there is a theoretical possibility that if I had not revealed that information, it would not be public even today, given the way the immigration courts have been, their extensive docket and how well, at least at that time, they tracked matters.
So, Mr. Murphy, so I'm not going to ask the questions that have already been asked. But
Mhm.
let's go back to when you first got the case.
Yes.
Would you do anything differently? Because you had resources to receive assistance. And I'm not hearing that you reached out to any of these resources to help you with the case.
So when I first became aware of the denial of LCQ's petition, it was month or two into the pandemic. Everything was shut down. I did not have although I had resources through my firm and I had resources through my mentor, I was devastated when I saw the ruling and I froze. I won't deny it. I can't defend it. I won't try to defend it. I am somebody who tends to try to do things, solve things, figure things out on my own as much as I can. And I didn't know where to turn. And I had the resources. I won't define. I'm sorry.
So is that professionally or personally? Because professionally,
Yes.
one would think that you would use your resources as it relates to your client and not matters of a personal concern.
It was not a personal concern. It was just, for lack of a better term, my personality type. It's hard for me to ask for help. And
you don't believe that when you enter the legal arena that you should suspend your personal beliefs and only adhere to the law and to the resources that you have to accomplish that task?
no, I know that I should. And I know that throughout the over 30 years that I have been a practicing attorney, this is the only matter that has ever come up before any disciplinary counsel. And yeah.
Mr. Murphy,
Yes.
what's the nature of your practice at the firm during these events?
So I was a staff attorney at the firm. I did whatever the firm asked me to do, for lack of a better term.
Were you in a practice group?
I was not. I have done everything from antitrust to securities to banking while I was with the firm.
Subject matter, but were you in court or what were you doing?
No, never in court, never had any clients, was never noted as a client for any of the matters on which I worked.
Mr.
In litigation matters?
Yes, but always supervised by partner, counsel, senior associate. So I'm familiar with the discovery process and deadlines, et cetera.
Mr. Murphy, in all the 30 years that you've been in practice, have you ever had a motion denied or an adverse result in anything you've been done? There any cases which you've been working ever?
Yes, in the sense of, I'm sorry. Yes, in the sense of when I was in private practice for the first 6 years out of law school, there were matters that, the result did not go the way I or the firm wanted.
All right. Now, in those looking back at all of those cases, did you think it was your duty in each one of those cases to let the client know that that unfortunate thing had happened?
Yes, and I believe I did so.
Well, then what went wrong here?
I don't know if it was a question of the pandemic, knowing that I was not an immigration attorney and I really was out of my element. I can't tell you why I acted differently there in this matter.
So the fact is that in the earlier occasions, you did respond appropriately, so you knew what it meant to do so, correct?
Yes.
Mr. Murphy, your initial 20 minutes has expired. You're still going to get your rebuttal time, but if there are other points you want to make in your initial argument, please get to those now.
Okay, thank you. The only real point that I want to make orally, because the board knows the various mitigating factors and other factors, is that looking at the 7 factors as outlined by Martin, I asked the board to weigh all of those factors equally. There is nothing indicates in any of the cases that I have read that more weight should be given to any particular factor. I would also note that although my client LCQ was prejudiced, it was not irreversible prejudice. All of the cases cited by the hearing committee, the prejudice to those particular clients were all not irreversible, where in LCQ's case, her prejudice was reversible. She had received everything that I was originally attempting to get for her, although with a delay. I won't deny that. But she was at no time in greater harm during my representation than she would have been had I responded and corrected appropriately given the immigration system.
Did she get her money back from the lawyer that she had to pay to take over the case after you?
I don't know. I did not know that she had to pay new counsel until the date of the hearing committee hearing. I know that she was referred by Kind, which refers matters for pro bono. And I do not know what actions my former law firm may have taken or not. But she was a pro bono client of the firm, and I was actively managing her case.
Any other initial points?
No, thank you.
Thank you very much. Mr. DeBoer?
Good afternoon. May it please the board. Disciplinary counsel asks that the board affirm the hearing committee report in its entirety. There are 2 issues raised by Mr. Murphy in his appeal to the board. First is whether Mr. Murphy violated Rule 4.1, and second is the appropriate sanction. The hearing committee recommended 90 days. Mr. Murphy asked for a fully stayed suspension. The sanction issue is of greater importance, but I will first touch on the 4.1 issue, which is fairly open and shut. In late March or early April 2020, Mr. Murphy learned that the petition for special immigrant juvenile status that he had filed for his client, LCQ, had been denied. And that was due to his failure to respond to a request for evidence that had been issued by USCIS. Rather than admitting his mistake and seeking help from his mentor at Kind, Ms. Teresa Lee, who, unlike Mr. Murphy, was a very experienced immigration attorney, instead he covered it up. He did not inform Ms. Lee or his client about the rejected petition until May 2023, more than 3 years after he learned about it. In the interim, Mr. Murphy had several email exchanges with Ms. Lee. Those emails form the basis of the 4.1 violation found by the hearing committee. First, on October 19th, 2020, Ms. Lee suggested that Mr. Murphy should contact USCIS to find out about the status of the petition. Rather than telling her at that point that it had been denied as he knew, he told her that he would check on it. Then 2 years later, in May 20th, 2022, Mr. Murphy emailed Ms. Lee to tell her that LCQ's brother, who he had also filed a petition on, had been approved for SIJS and had received deferred action status. In that same email, he told Ms. Lee that he had, quote, not received anything, unquote, for LCQ. As the hearing committee found, both of these statements by Mr. Murphy amounted to false statements of material fact to a third person and therefore were violations of Rule 4.1A.
Mr. DeBoer, Mr. Murphy, on the second statement there, focuses on the fact that he very narrowly tailored his statement so that it was not, in some ways, not a false statement or a misrepresentation. Can you respond to that position by Mr. Murphy?
Sure, and he took that same position before the hearing committee, and it should be noted that it was expressly rejected by the hearing committee, and that they found that Ms. Lee understood it to mean that he had not received anything at all with regard to LCQ. But more fundamentally, Rule 4.1, the very first comment, says that there do not need to be affirmative false statements in order to violate Rule 4.1. There's also the omissions of material fact, or also technically true or partially true but misleading statements. So there's really no doubt that the statements were at the very least misleading, partially true but misleading, or omissions. In fact, Mr. Murphy has admitted in his brief, as he did to the hearing committee, that he, quote, lied by omission. And he's given no response to the comment one when it was raised by disciplinary counsel in our brief. He totally dropped the issue in his reply brief and has never said why it wouldn't apply to his situation.
Counsel, could you help me a minute here? What is the operative definition of materiality? Where would I go to find some place where the Court of Appeals says the materiality is?
I don't have a case off the top of my head. It may be in the definitions, Rule 1.0, but I'm not sure of that. But it's hard to imagine any fact that's more material to LCQ and to Ms. Lee, who is supervising this attorney-client representation, than the fact that her petition had been denied. That was the entire purpose of the representation. So it really stretches the mind to think of how that couldn't be material, and I don't believe he argued before the hearing committee that it was not material. He made some, as the hearing committee said, vague statement about there's questions about the materiality, but he provided no case law to suggest that this was not material, and I think it's pretty obviously material. So the board should uphold the finding of a 4.1 violation, but more importantly is the issue of sanction. The hearing committee recommended a 90-day suspension, and as they laid out in their report, 90 days falls squarely within the range of appropriate sanctions for cases involving neglect and dishonesty. And the hearing committee listed a number of cases from a 30-day suspension stayed all the way to a 1-year suspension. In his brief, Mr. Murphy ignores the cases that the hearing committee cited that were higher than 90 days to make it seem like his case is an outlier, but you have to factor in those other cases as well. And the actual outlier would be if a fully stayed suspension was imposed, because the only case cited by the hearing committee with a fully stayed suspension was the Evans case. And as Ms. Rice Hicks correctly pointed out, there is no 8.4C charge in Evans. There was no finding of dishonesty, and then if you read the board report, it says there's no allegation of dishonesty. So it was included in the hearing committee's analysis, but it's really not a comparable case. Here, as the hearing committee said, dishonesty was at the heart of Mr. Murphy's conduct, violating not just 8.4C, but also 4.1. All the remaining cases cited by the hearing committee included a served suspension. Mr. Murphy argues that his case is less serious than some of the other cases like Cole and Outlaw. But as the Court of Appeals has stated on numerous occasions, sanctions are not an exact science. And it must be pointed out that Mr. Murphy's dishonesty was for a significantly longer period than those other cases, almost over 3 years of deliberately hiding the truth from both his client and the mentor, Ms. Lee. But the most significant reason why a 90-day sanction is appropriate is because of Mr. Murphy's continued efforts to minimize his misconduct. This was extremely serious misconduct. LCQ was a very vulnerable client, about as vulnerable as it gets. She came to the United States as a minor, having fled dangerous gangs and in an abusive family situation. For over 3 years, Mr. Murphy left her in the dark about the true status of her case. All that time, she was at the risk of deportation.
I have a question about that.
Yes.
In the context of the 1.3B2 charge
Mhm.
violation, there seems to be some dispute about whether getting the SIJS status would have protected LCQ from deportation. Does it? Does ODC have a position on that?
Well, the way it worked was that the USCIS was granting deferred action, not because it was being asked for, but whenever an SIJS was approved. And there's some degree of speculation that's required, but not too much, because she came into the country with her brother. Mr. Murphy also handled her brother's case. And when her brother's SIJ petition was approved, he was granted deferred action. And that gave him both putting him in a much less precarious position as far as deportation. It also gave him the opportunity to apply for work authorization, which is something that Ms. LCQ was denied due to Mr. Murphy's misconduct.
And is it ODC's position that respondent was aware of that potential prejudice to LCQ at the time of the misconduct? Again, for purposes of 1.3B2.
Sure. Well, he was, as I said, he was handling LCQ's brother's case. So certainly he was aware that deferred action status existed and that it could be conferred as a result of the SIJS petition being approved. And it is not a small matter. Work authorization is an important thing for an immigrant, especially one who is raising a small child like Ms. LCQ. And then finally, once everything did come to light, as Mr. Walker noted, LCQ had to pay for an attorney to fix the mess that he had created. So the idea that there was no real prejudice is not correct. And that attitude, which he also displayed at the hearing committee, was really the main reason why the hearing committee thought 90 days was appropriate and that he shouldn't receive a state suspension as he requested. And in his brief, Mr. Murphy also has continued to attempt to shift blame onto Ms. Lee. He complains that the hearing committee held him to a higher standard than Ms. Lee. But it was Mr. Murphy that had the attorney-client relationship with LCQ. He had the fiduciary duty to the client. Ms. Lee was available to assist him, but when he needed the assistance most, he refused to seek her help, and indeed actively concealed the situation from her. So he essentially short-circuited the support system that was in place for these kind pro bono volunteers. So it's that attitude that informed the hearing committee's recommendation, and in light of the seriousness of the misconduct and Mr. Murphy's continued failure to truly acknowledge the extent of his misconduct, the 90-day suspension recommended by the hearing committee is warranted, and we ask that it be affirmed. Unless there are any further questions.
I do have one further question. What of the items of prejudice to the client we have identified, what is ODC's position on which of those respondent was aware of? That is, was respondent aware that she might have to hire another attorney and pay fees post receiving pro bono. Is it, yeah, again, I'm trying to distinguish between the prejudice for sanctions purposes and prejudice for knowing prejudicing the client. 1.3.
Sure. I mean, I'm not sure how important it is that he knew what the exact prejudice is. Certainly, he knew that his case, there's going to be consequences for LCQ based on the fact that she'd been denied this petition. The entire purpose of the representation was to get this petition. Obviously, there was a benefit to it, specifically being able to apply for a green card. So the fact that, maybe he thought she would be able to get another pro bono attorney, I don't think that's really that relevant. And at no point did he offer to pay for her new representation. He said multiple times that he apologized at the first opportunity at the hearing, but why was that? Why wasn't he able to? He had her email address. Why couldn't he have reached out to her before that and apologized? So it really, I'm not sure how important it is. The fact is that she was prejudiced, and also just the uncertainty of knowing that her case has been botched, being up in the air like that is certainly prejudice as well, and as the hearing committee found.
But for purposes of I take your point for sanctions, for purposes of 1.3b2, respondent would need to know, or at least be aware that the client was prejudiced.
Yes, but again, just the very fact that her petition was denied and sat for 3 years is certainly prejudice, as the Court of Appeals has said. Delay alone can be prejudice, and even just the uncertainty of not knowing, thinking her case is being taken care of, and actually it's, been lost for over 3 years is certainly prejudice as well. And he knew all that. Any other questions?
Thank you, Mr. DeBoer.
Thank you.
Mr. Murphy, you have your reserved rebuttal time.
So real quickly, I would like to point out to the board that as noted earlier in the Evans case, which was 30-day suspension or 30-day suspension with 1-year probation, that in the Evans matter, Evans had a history of violations. This is the only time I have ever been before any disciplinary board. In the Evans matter, the prejudice to the client was irreversible, where my prejudicial actions to LCQ were not irreversible. Similarly, in Cole, which was a 30-day suspension, the client was permanently prejudiced, and there was actually an order of removal given to the client. It was a similar immigration matter where LCQ never had an order of removal to her. As an outlaw, that was a 60-day suspension, and the attorney in outlaw actually affirmatively lied to the board at her hearing committee, where I have been honest and forthright with all parties from the time I received my initial disciplinary notice and my initial response, all the way through private meetings with the hearing committee and with this board. And as I mentioned, that was 60 days also. I believe my actions are not as egregious as any of those. Finally, I would also like to note that paying would be a mitigating factor and not a prejudicial factor. And for all of the reasons stated in my briefings and stated here today, I ask this board to, if it determines a violation is appropriate or sanctions are appropriate, that 30-day sanction with 1-year probation is appropriate, with conditions if the board believes necessary. Thank you.
Thank you. The case is